do all the jobs what are done at the trial court level. Law schools, I can say that now you people are getting opportunities by way of these law universities, who are getting the best of the faculties for you, providing you best of the opportunities. I can't teach you law in one day. There is a concept of court crafting.
Yes.
You know the law, you know the case, you know the judge also. Which bent of mind will he? What will he appreciate, what will he not appreciate? It is not always good. At times the client says that you have not spoken anything in the court. There are clients who are having this problem with us. That when the matter was arguing, the other lawyer was saying so many things and you were kept silent.
Greetings everyone. Welcome to DNLU podcast. I'm Vibhuti Mittal, a 4th year student at DNLU Jabalpur. Today we have Mr. Ateev Mathur with us. He's a partner at the litigation vertical of SNG and Partners law firm in New Delhi. Sir has completed his undergraduate in BA-LLB from GNVU and Diploma in Intellectual Property Rights from Indian Law Institute, New Delhi. With over 20 years of experience in legal practice, he represents the firm in various litigation and including other areas of banking, FEMA regulations and property disputes before Supreme Court and various high courts and tribunals. Sir has contributed to various platforms such as Economic Times, Business World and among others. He has been recognized in the annual list of 40 leading dispute resolution lawyers in the country by ALB India. Thank you, sir, for agreeing to sit with us. Now let's dive into the questions. Let's begin with your journey into the law field and how you rose to the ranks, how you started from the scratch and you reached to the position of partner.
Yeah. So I understand that this question is of some importance for the young minds, young brains. So if I look back of my journey, I started my career in 2002 and I did my law from Jodhpur, as you have noticed. After joining the offices, chambers, first I started with the office of Mr. Govind Mathur, who elevated as an High Court judge, retired as the Chief Justice of Alawa High Court. I worked with Mr. Ashok Mehta in Jaipur, and thereafter I came back to Delhi. So if you see as the progression, if as a lawyer, what you look is the opportunities. So in Jodhpur, I was getting an opportunity of a particular field. Yes, I'll say that, yes, I was getting opportunities. When I came to Jaipur, the opportunities, because it has more commercial world in Jaipur than Jodhpur. So I got further opportunities in the commercial world, and fortunately I got the exposures also, the mentoring also. And when I came to Delhi, I'll say that my experience and my knowledge base, what I gained from my old experiences in Jaipur, Jodhpur or my chamber offices, it helped me to carve out my position in the firm to be an original side practice. As we say in Delhi, there is a civil side practice and Delhi High Court has an original side practice also. So in the original side practice, you've got to have a command on the civil laws, your CPC, your procedural laws. I started my career as an associate. So I can say, I always say that in a firm, I am the one who has worked on all the positions. So I have been associate, senior associate, principal associate, associate partner, and now partner, equity partner. So whatever you say that it happens only with the experience, with the hard work you do. I'll not boast for myself that I have worked hard, but yes, the mentors must have seen something. The only mantra I would like to give to the young brains who are watching this is that keep on working. As I said earlier also, and I'll repeat it, don't do overthinking about yourself, your career. Your career will shape up. Do work. Do start working to the utmost sincerity, to the hard work. The files, the briefs which are handed over to you, just read them carefully, word by word, make notes. And each day when the matter is coming up, just read it again. Don't say that this matter I know.
So, yes, sir. So, sir, thank you so much for sharing that. Now, since you have shared that you started in Jaipur, Jodhpur and Rajasthan courts and then you moved to Delhi. So, students interested in litigation often face this dilemma as to when they are interested in litigation, should they join a chamber, should they join a firm's litigation vertical? And since you have experience in both, so what's your opinion on that?
Yeah. So my My sincere opinion to the people who are wanting to join the litigation practice is that be patient. Don't hurry up. There is no easy way. As we say to the young kids also, there is no easy money, there is no easy way in the profession, especially in the dispute practice. Secondly, start your practice with the lowest forum of your specialization. If you are practicing on the civil law, go to the civil judge, do the trials. If you have done trials for 2 years, 3 years at least, you have done as the best of the lawyer, you will get hesitations once you do the first cross examination of your life. The witness may be a person who has experience of cross examinations, but the lawyer is asking the question for the first time. So it will give you jitters to ask a question to someone. So do trials for some few years of your time. Do all the jobs what are done at the trial court level. Do all filings, all ministerial acts also. You will get the feeling of what the code is, what the procedure is. Then move on to the higher courts, high court, supreme court. You can develop your practice in area and everywhere. But start from practice for some time. And coming back to your question, to join the chambers or the law firm, it depends upon the opportunities you are getting, which chamber you are getting and which law firm you are getting. Not everybody has the choice of opting out where to join, but if you are getting an opportunity, depending upon the kind of nature of opportunity, I will advise for a couple of years of your initial career, go for chamber practice, because there you will get this opportunity. But again, I am not saying that if you are getting an opportunity as a fresher in a law firm also, don't take it. If you are getting an opportunity, please take it. Do take it. But then start working from the bottom. Don't think that my senior is not coming on a Saturday, so I will also not come on a Saturday. Don't think that he has gone by 5 p.m, so I will also go by 6 p.m. You are there to work. Your senior has worked for till 10 p.m. already. He has worked that hard work. So it depends upon the practice to practice. But yes, if you are getting an opportunity from the way I am suggesting you, or from my experience, to go the core work of the litigation practice. The word is core work. So if you are getting that opportunity wherever, in the law firm or in the chamber, you must grab that opportunity first. If you are getting an opportunity for a Supreme Court practice directly as a fresher, I will advise you to be a little cautious.
Moving on to the next question. So we see that young students are often not that swayed towards litigation because of the recent trends in corporate areas, and so they see that joining even litigation in a chamber, and even chamber is far away from the question, but even in a firm, they kind of they hesitate. So what would you say to such students, to such young lawyers?
Look, yes, you are right. You are hesitant in saying that, but the monetary considerations are the considerations which are little less in the litigation practice for the initial years, and in the corporate world, yes, you have been absorbed on a much higher packages, and that tend to attract the young brains. But I'll only say that even if you are going for a corporate practice, you must have an experience for couple of years in the litigation practice. You know why we say so is because as a corporate lawyer, and my corporate friends may tend to differ it from me, and everybody has his own thought, because when you go for a corporate practice, you do a documentation, you do a structuring, you do advise a client, you should know how ultimately any contract, when it goes to a dispute, why we make a contract. Otherwise the parties can work together. Why we document a contract, why we document everything, is because in the eventuality of a dispute, this document will come handy, and these defines our term. So when it comes to a dispute, the parties won't resolve it themselves. Either it will go to arbitration or it will go in the courts. So we should know how this contract will be read in the court. How a judge or a lawyer who is arguing a matter for you or against you will interpret this provision in a particular manner. What the case law has developed. I may read a textbook in a particular fashion, but at times we see that the textbook has been interpreted by the courts in a particular fashion. So it is ultimately the law of the land which is being interpreted by the courts which will prevail. Obviously the textbook, the Bare Act has its value and it will prevail. I am not saying that. But the dispute will be resolved and adjudicated by the courts. So you should have a minimum couple of years experience to see the things, how the things will move on in the court, And then depending upon your interest, you can move on to the corporate world also, and you can continue with the dispute also. And I'll say that the legal profession, as you say that, legal profession is a legal profession of a little patience. So all my young brains, young students, young friends, I'll say that please be patient. Don't run. You can't buy a Mercedes in the first year. You may buy. There may be people, I am not discounting their abilities, but be patient. You will one day you will get it, but continue to work. But you will not get everything on the first day. No doctor will get a, even if you join the profession of the doctor, they will also do residency work, they will also be a junior, then they become a surgeon, and then they are the sought after doctors. So every profession has its own space, and its space to work on. So let us focus on and guide the young brains on that aspect of the matter. Then money is everything, but not everything. I'll at the same time say so. So focus be on money, but on a gradual manner.
Okay, so picking up from the interpretation of quotes in textbooks and how we as young lawyers see textbooks and how courts interpret it, what's your opinion on how law schools should keep up with the emerging trends, and how you see that even when you handle the interns, when you see the interns, how their mind in law school and how they should develop it when they come to work, when they actually learn the practical aspects of the law. So what do you think should law schools inculcate, and how the law students, the young law students who are just getting into the practice, should keep up with that?
So the young law students who are just graduating, there is a lot of things which are going in their mind. They have seen so many good things also in the market. There are things which are not appreciated also, but they have seen it. So obviously they are in a dilemma what to follow, where to follow. So law schools, I can say that now you people are getting opportunities by way of these law universities, who are getting the best of the faculties for you, providing you best of the opportunities, helping you out to how to handle the market pressure. So what best they can do, I'm sure they are doing it. You have the professional guidance you are getting the exposures of the moot courts also. The only advice I will say is that while in law school, as a law student, just adhere to your first principles. What we say is the first principle is what is taught in the law school is at times considered as boring by the law students. It is often said that I don't attend X class or the class of a Y professor, or I don't like this subject. Most of the law students I have heard is they don't like administrative law, jurisprudence. They think they are boring subjects. But I can only say that when you come to the actual world, actual practice, after a couple of years, when you start interpreting the law, applying the law in a particular case, when not the routine matters, when the ticklish matters start coming to you, where the interpretation is involved, this is the core which will come handy to you. It will not be possible for you to at that time go to the law any professor to understand this concept. You won't be able to read those books, read those judgments, and even if you read, it will consume a lot of time of yours. If today somebody asks you to go buy a book of Wade and ask me to buy a book of Wade and read it entirely and then understand the concept of administrative law, it will consume my entire board. 4 5 days or 7 days or a week or month will go by, and I won't understand that much. But if you have understood it today, what are the principles of natural justice or the basic concepts of the first principle concepts, you will be able to apply it in a proper manner. And once you will start applying it, you will have an edge over the above the others. So that is the advice I would like to give to all young brains, that law colleges are doing their best. I can say so. You are getting the opportunities. Just grab those opportunities in the most particular manner. And secondly, when you are reading the judgments, it is my experience with the interns also, at times your approach is casual. The students' approach is casual. I have found at times they are not able to differentiate between what is the ratio and what is the obiter of a judgment. So this much law schools should guide that yes, this is the basic core of the judgment, and which is what we technically say is the ratio of the judgment, and this is how it is to be applied. So the case law study, I'm sure you people must be now given the case law studies also,
Yes.
and you people must be doing it. And second is the concept of client interaction, which is most. As a lawyer, as a young lawyer, when you are doing your own practice and you get an opportunity when a client reposes confidence in you and he approaches you, you are very happy, you are very elated, and whatever client says, you will tend to do it. At that time, there has to be some sense of discretion. What client is saying is not the gospel truth. So a lawyer must be taught also how to, in a way, grill a client in his chamber so that a actual truth comes out. And if that actual truth, you can put it across to the bench, put it across. If you feel that your client is not the telling you the correct truth, or the facts as stated are not the correct, you may very well step out of the case, giving the brief back to the client, boss, you are not giving me the correct facts of the case. But don't place incorrect facts to the court. If you don't know, say I don't know, but don't say incorrect things to the court. The bench once loses confidence in you, it will lose forever. You will never gain that confidence back.
True. And there are client consultation competitions happening in law schools nowadays. That is kind of a way to hone these skills of law students. But as you said that, I believe that in theory it's far different, and in practical life it's far different. What happens in the chambers, what we as students see in our internships. So
clients are also nowadays with the availability of the social media, the internet. So now not only the doctors are getting this problem that the client goes to Google and sees the prescription for the medicine. The clients are also coming to the lawyer and they will start arguing, why are you not doing this and why are you not doing that. So at times we feel that I can't tell you the practical aspect of the matter. I can't teach you law in one day. There is a concept of court crafting.
yes,
You know the law, you know the case, you know the judge also. Which bent of mind will he? What will he appreciate? What will he not appreciate? It is not always good. At times, the client says that you have not spoken anything in the court. There are clients who are having this problem with us. That when the matter was arguing, the other lawyer was saying so many things and you were keeping silent. So, what to speak and when to speak is one thing, but you got to know that when not to speak and what not to speak. That is also but that thing can't be taught you in the law school. Now you will get to know about it in the practical field. But keeping silence in the court is also an art.
yes,
We have seen cases, in my practical life, I have seen cases where the judge was giving us relief, and in the overzealousness, in the client's pressure or whatever, inexperience, we tend to say something to over buttress our argument, and that over buttress, the thing will slip on. The judge will then go, okay, then if this is the case, I will ask them to file a reply or something will happen. So to keep a silence in the court is also an art. When and what, to what extent?
sure, sir. So my last question to you would be that with what mindset do you prepare the case? Like since you have such a vast experience and such a rich experience, with what mindset when you prepare the case, and how does it develop when you go on to argue it and you go on to defend your case? And like, is it like a warlike mindset? Is it like a calm, composed mindset? As you already mentioned that you should know when not to speak, and often young law students, young blood, with the zeal, with the I can say with the motive to win it, they often commit novice mistakes, amateur mistakes. So what's your opinion on that?
There is no other option, there is no other opinion on this aspect. When you are entering the courtroom, you should enter the courtroom with the most composed and calm mind. You will get a composed and calm mind only when you have well prepared with the matter. Even today it happens with us. We are preparing a heavy matter, we are preparing a matter. I have read that brief, I have prepared my notes, I have done my research. Still, in the middle of the night, some thought will occur to me that if this question will be asked by the opposite lawyer or by the judge, how will I handle it? Whether I have placed that document on record, whether that document has this word, this sentence, whether I have set up a case in this fashion or not. So nowadays we have the facility, the entire files are on the iPad and all. We'll open it, we'll make a note of it. But in the earlier days also, I will make a note of it. Some judgment, some work will occur to me, and I'll make a note of it so that I can, the moment I reach my office, I'll ensure that this thing is there. When you are entering the courtroom, your client, when he is coming to you, he has parked his stress onto you.
Yes.
He is going home safely, he is sleeping. When the next day matter is coming on a procedural day, on a some day, at times the clients are not even aware of. And if it is an institutional client, nobody bothers. ठीक है, there are law officers जो भी हैं वो they keep a track of the matter. But for a individual client, he may not be aware that the matter is listed. You have taken over his stress. If you will top it up with your own stress, so it's going to burst in the court. So our job is to remove his stress, put a filter in our ear, put a filter in our mouth. Whatever client is saying, hear it with the filtered ear. Whatever is to go in the brain will go in the brain, and whatever is to come out of the mouth will come out of the mouth. If whatever client is to say is to I have to act as a mouthpiece of the client, the client might better argue the matter. He knows the fact better than me.
Yes.
I have read, I have prepared whatever he has told me. तो हम हमेशा मैं ये कहता हूँ सबको कि क्लाइंट ने जो कहा है उसको आप जितना चैम्बर में ग्रिल कर लोगे क्लाइंट को, क्लाइंट में एट टाइम्स क्लाइंट डोंट लाइक इट. Why are you grilling me? Are you accusing me? And you have to tell him, I have to ensure that I am getting a right facts from you. With the passage of experience, you will get to know, you will understand that something is fishy about the facts which are being narrated by the client. But that you will get to know with the experience. And just imagine the judge who is sitting there. He has far more experience than you. You are doing 5 matters in a day. He is doing 50 matters in a day. And he is doing far more years than you. So he'll open the file and you'll get to know that where is the fishy affair. And if he has a misconception, then it is lawyer's job to remove that impression from him, to clarify things. You will have to read the read the mind of the judge also, what is going on in his mind, and answer accordingly. Don't start arguing the matter the way you have prepared yourself. There may be a situational improvisation which is required. The judge may ask you some irrelevant question. You've got to be prepared about it. You've got to be prepared on law, facts, circumstances. You've got to be prepared about the latest trend which is going on. I cannot go and argue a matter before a judge on a particular law point which he has decided against me a couple of days back in a judgment. I am not even aware. I have not read his judgment. That what is his viewpoint. If his viewpoint is against me, I must quote my case accordingly. That you have not considered this aspect of the matter, how my case is distinguished from that. So it is a typical warlike situation, I can say so, but war of minds. So war of minds are more stressful, I can say. The physical stress you can remove, you can come and rest, but the mind will keep on working. And for the young students, I can tell you, it happens with us even today. If I have briefed a senior counsel for a particular matter, I have briefed him. The client has parked stress on me and I have parked my stress on the senior counsel. And now I am also relaxed. I am roaming around in the courtroom very freely that I have parked on everything to him. It is his problem. He will handle the judge. And suddenly the counsel calls me that, look, I am not able to come. I have another matter. You handle him. Suddenly my brain will start working on a double up speed. So, okay, now the thing has come back to me. Now all those questions will start coming to my mind and I ask myself, where were these questions half an hour back? So that happens with everybody.
Okay, sir. Thank you so much, sir.
Thank you.
With this, we have come to an end of the podcast, and I really thank sir for taking out time and sit with us with this session and share his insights. Thank you so much.
Thank you so much.